Welcome to the Commercially Connected Bitesize podcast series from Evershed Sutherland. I'm Angela Kindness and my co-presenter is Sara Ellis. We're professional support lawyers in the commercial team at Evershed Sutherland, and today we're going to take a look back at the lessons learned from some of the key cases in 2025 and how these impact on commercial contract drafting.
But before we even get to drafting lessons, we had an important reminder from the Court of Appeal this year that it's really easy to form a contract under English law when they found that a contract had been formed via WhatsApp and email messages.
Yes. So remember that in a dispute over whether or not a binding contract exists, a court will look at the whole picture and all the communications between the parties to assess whether the parties have reached an agreement to be immediately and legally bound. That's why it's so important to make it clear in pre-contract communications and negotiations that you don't intend to be bound and to make all comms subject to contract.
Absolutely. So, moving on to written contracts and lessons for drafting, we had a Supreme Court decision towards the end of the year which looked at conditions precedent. And by that, we mean conditions that have to be fulfilled before the contract or part of it or certain obligations under it come into force.
Yes, and this one underscored the importance of making sure your conditions precedent clause makes it clear who has to do what, by when, and what the consequences of failure to fulfill those conditions are.
And staying on the theme of conditions precedent, there was also a Court of Appeal case on the point that you don't actually have to use the words condition precedent to create one. Any drafting construction that creates an if this, then that structure is a condition precedent. So if you have to give notice before claiming liquidated damages, as was the case there, then the notice is a condition precedent to getting those liquidated damages. Fail to give the notice in compliance with the clause, and you don't get the LDs.
Moving on to implied terms now. We had a Court of Appeal case in the summer where a contract said that part of the price was to be agreed by the parties. They failed to agree, and the dispute was over whether or not a term could be implied that in the absence of the agreement, the price would be reasonable or market price.
Now, in this one, the Court of Appeal said, yes, the term will be implied. There was a counter argument run that because the price was reserved for agreement by the parties, the Sale of Goods Act implied term that the price had to be a reasonable one was excluded, but that argument failed.
So the moral of the story is, first, make it very clear what the pricing terms are. And if part of the price is to be agreed, consider including a fallback to make it clear what happens if that agreement is not reached. Such a fallback might be the matter goes to expert determination or using the internal dispute resolution process, for example.
Secondly, remember that as well as the express terms in your contract, terms can be implied on various bases. So they can be implied on the basis of usage or custom, by statute, like the Sale of Goods Act, by the party's previous course of dealing, as a matter of law because of the type of contract, and as a matter of fact, where the term is so obvious that it goes without saying and is necessary for business efficacy.
So now, a year would not be complete without some cases on exclusion clauses, and 2025 has been no exception. In one case, the Court of Appeal had to look at what exactly was covered by an exclusion of liability for loss of anticipated profits, with the leading judge finding that in the context, the term meant essentially the same thing as loss of profits.
But it's really important to stress that this was decided as a matter of contract construction of the specific contract, and it doesn't mean that all clauses excluding loss of anticipated profit will automatically be construed in the same way. And there was disagreement between the judges on how they reached their conclusion, and there was also a dissenting judgment. And that all goes to show how difficult it can be to predict how an exclusion clause will be interpreted on the facts of a particular dispute. So you should always stress test your drafting as much as you can and make sure that it's clear what it means on an objective read through.
From another case on a dispute over how to apply a liability cap, we had a reminder that you should always make it clear that the primary obligation to pay the contract price does not count towards a party's liability cap. And this is really important in supplier side contracts.
That case also considered whether a contractual entitlement to interest falls inside or outside the liability cap. And although the Court of Appeal's comments on this were obiter, they said that clear words would be needed for interest on late payment to be inside a liability cap.
So, where does this leave us? Well, we think, following this case, that unless you expressly say that interest is inside the cap, it's likely that a court will find that it's outside and doesn't count towards the cap.
Yes. And staying on the subject of interest, we also had a case this year that looked at whether or not a default interest rate of 4% a month was a penalty.
As a reminder, an obligation to make a payment on a breach of contract won't be a penalty if it's included to protect a legitimate interest of the party seeking to rely on it. And it shouldn't be extravagant, exorbitant, or unconscionable. It all needs to be proportionate.
The key point that came out of that case was that when you're making an assessment of a default interest rate, if that same rate is charged on the occurrence of various different defaults, you have to make your assessment of whether it's needed to protect the lender's legitimate interest in relation to each individual event of default, not just the one that actually arises.
Yeah. So lenders and other businesses charging default interest should stress test their interest terms at the point of entering into a contract to maximize the chances of these being enforceable if they need to rely on them.
Staying on the topic of defaults, we had a Court of Appeal case that looked at issues around remedying breaches of contract, and there were two key messages that came out of that case. First, whether or not a breach is remediable usually comes down to whether matters can be put right for the future. And then, secondly, if you've got a clause that says you can terminate for a remediable breach that isn't remedied within a certain number of days of notice, you must serve that notice and give the opportunity for remedy before you purport to terminate for the breach.
Now, the last case we're going to mention today is on the subject of termination. Remember, if a party is entitled to terminate a contract, whether by exercising a common law or a contractual right, they have to choose whether to exercise the right and terminate the contract or whether to affirm the contract and carry on performing it.
That's right. And this Court of Appeal case made it clear that in order to make that choice, the party needs to be aware of both the facts that give rise to the right to terminate and the fact that they have the termination right. So in this case, that meant that a party was able to terminate a contract several months after the events giving rise to the termination event, because it was only at that point in time that they became aware that they had the right to terminate.
So this principle could provide an exit route for a party that wants to bring a complex contract to an end, but it's definitely a risky approach, as relying on a right that has arisen at a point in the past is likely to lead to dispute on whether or not the party actually knew about the right earlier.
Yes, and depending on the facts, there could also be a dispute over whether the parties is stopped from exercising its termination right because of its words or conduct on which the other party has relied to its detriment. You don't need to be aware that you have a termination right in order to be stopped from exercising it.
So, the moral of all this is that if a contract dispute arises, it's always important for each party to understand what termination rights it has and that it needs to make a swift decision on whether or not to exercise them.
So that brings us to the end of our whistle stop tour of contract case law from 2025. The citations for all the cases that we've referred to in this podcast are on the screen. Look out for our next Commercially Connected Bitesize on what's in store for commercial lawyers in 2026. We'll see you next time.